Hello, I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this open government lesson. This class is an update to the many public record presentations now available in our FOI guide. I strongly encourage you to view those lessons prior to watching this one. All of our lessons are cumulative. They start you off with the basics and then move into more complicated, nuanced areas of law. So what you learned today is intended to catch you up on the changes to the law since our introductory lesson 4 years ago. You can find that lesson and all others at nefac.org/FOI guide. This presentation is supported in part by the Rhode Island Foundation and the estate of Gloria L. Negri. Gloria was a trailblazing journalist at the Boston Globe for more than 50 years. This program is part of her legacy of newsroom education and her lifelong commitment to local journalism. You can learn more about Gloria and other NEFAC supporters at nefac.org/supporters. During today's presentation, please introduce yourself in the chat and share your own experiences and resources. You can also use the chat or the Q&A button to ask questions of our instructor, and we'll get to as many of those questions as possible. All right, let's begin. John, all yours.
Thank you, Justin, and thanks to NEFAC for having me today. My name is John Marion. I'm Executive Director of Common Cause Rhode Island. I am not an attorney, and this isn't legal advice, but we are going to review, as Justin said, changes to the Access to Public Records Act, which is Rhode Island's FOIA law since 2021, as well as some interpretations of that law and some proposed changes to the law. As Justin said, there is a video that is sort of the foundation. It was by Mark Friel, an attorney in Providence, that was shot in 2021 and really walks you through how the law functions. So I'm just going to build on top of that. So today we're going to talk about three things. One, we're going to talk about the very few changes there have been to the Access to Public Records Act, or what I'll refer to as APRA, since 2021. Then we're going to talk about some notable interpretations of APRA since 2021. And then finally, we're going to finish with a bill that NEFAC and Common Cause and our coalition Access Rhode Island has been putting forward and supporting for several years that would make a number of changes to APRA. So the first thing we'll talk about are changes to the law, and don't get too excited. There weren't many. Really the only change to the actual statute is here in this underlying language in 38 Rhode Island General Law 38224IB, and it basically makes non-public the city or town residents of police officers in the state, referred to in the statute as peace officers, but what we would think of as police officers. And so no longer, after this was adopted in 2022, is the city or town of a police officer a matter of public record. There was another change, and it wasn't in APRA, but it referred to APRA, and again, it's underlined at the bottom of the slide. There is when school districts lay off teachers, which has to do with school funding, and notice to the teachers that they might not be brought back the following year. That statute in 1613(9)(c) here, it clarifies that that list of terminated teachers is not a public record for purposes of APRA. So not a lot of changes. There have been many proposed changes, as we'll talk about soon, but not a lot of changes. In Rhode Island, APRA is largely interpreted by two different bodies. One is the Superior Court. So under Rhode Island law, if you want to get a public record and you're denied a public record, you can go to the Superior Court and ask the court to release the record or order the record to be released. That is not very common. In fact, there have not been any notable cases that have been decided since 2021 from the Superior Court. The far more common option is an administrative option where you can appeal to the Attorney General of the state of Rhode Island. And the Attorney General has an open government unit of several lawyers who issue determinations based on these appeals. And so the next thing I'm going to walk you through are about 10 notable appeals since 2021. There are anywhere between probably 30 and 50 of these decisions made by the Attorney General each year. I just picked out what I thought were some interesting ones, particularly for journalists, because I think that is one of the audiences for today's webinar. The first one was going back to 2021, and it was Tim White, a reporter for WPRI, asking the Providence Police Department for some records. And I underlined at the bottom what I think is notable. So this is the synopsis of the decision published by the Attorney General on his website. And Tim had asked for a waiver of the fees that were going to be charged by the Providence Police Department to obtain these records. And the Attorney General here said essentially that, even though there might be a public interest in these records, he doesn't, or his office doesn't have the ability to waive those fees. It was a little bit of a it wasn't relevant to the decision about whether the records were public or not, but it was notable because this is something that we are seeking to change in the law, as I'll discuss later. The second one involves the Providence Journal against the seeking records from the Rhode Island Convention Center Authority. And what I thought was notable about this is they were seeking some personnel records, and normally these types of personnel records or for public employees are public explicitly under APRA. But the Convention Center Authority actually doesn't employ many people. It actually just pays a vendor who employs people. And the Attorney General ruled that even though they're employed by a private entity, their personnel information is subject to APRA. And so as it says in here, that SMG, which is the vendor, is considered a public body for purposes of APRA, and that means its records are public. And it said essentially to the reporter, hey, if they don't produce the records, the Convention Center Authority doesn't produce the records, you should go to the vendor and ask them. So I thought that was notable for two reasons. One, I think it's good of the AG to interpret it that way. This is erring on the side of transparency, even though it's a private company. But also because the AG took the time to kind of point the reporter in the right direction of what they could do. The next one's from 2022. This is Eli Sherman, again at WPRI. And he had requested some records from the governor's office. Notes on this. And this had to do, this was very high profile. Governor Raimondo had resigned to join the Biden administration. Lieutenant Governor McKee became our new governor. He had to pick a new lieutenant governor, and he had an open call for applications, and he had a firm do background checks. And so in this case, Eli Sherman was trying to get copies of those sort of background checks. They weren't police background checks, but rather just sort of political background checks. And the AG decided that, yeah, those are a public record, even though they were produced by a private firm, because they were in the possession of a public body. However, because it was part of a deliberative process of choosing a new AG or new lieutenant governor, it could be withheld, and also because of the privacy interests of the potential candidates for lieutenant governor. The next one is Kathy Gregg from the Providence Journal, and again, Eli Sherman from WPRI, seeking records, particularly emails related to a trip that two Rhode Island officials took to Philadelphia. This was a very, very high-profile story in Rhode Island, and the governor's office had withheld quite a few of the records and emails related to the misconduct on this trip. And the AG came in here and required that they be disclosed. I raise this, one, because it's high profile, but also because it involves the balancing test. So in 2012, the last time we fundamentally sort of reformed the Access to Public Records Act, we put the balancing test that exists for individually identifiable records that exists in the Federal Freedom of Information Act into Rhode Island law. And this is one of the first cases where it was applied in a high-profile case, and the Attorney General decided that the public interest outweighed the privacy interest. So this is notable for the application of the balancing test. Again, 2023, this was Patrick Anderson of the Providence Journal and Tim White, again, from WPRI. This involved a special election for Congress where Lieutenant Governor Sabina Matos's campaign had submitted some fraudulent petitions, signatures for the nominating petitions for that seat in Congress. And one of the towns in the 1st Congressional District, Jamestown, decided not to release those petitions, arguing, among other things, that it was an invasion of the privacy of the petition signatories. The Attorney General ordered them released, although there were some redactions allowed. And this was important because the entire point of these petitions is to show public support for somebody to have access to the ballot. And so if they were kept private, it would defeat the purpose of even having the petition signature process. Next, from 2023, some activists and researchers were seeking crash data. So each city and town compiles data about car crashes in their communities, and they have to report that to the State Department of Transportation. These researchers were particularly interested in crashes in the city of Providence, and they went to this State Department of Transportation and asked for that data. What they were told was that it couldn't be released because there is a federal law that prohibits the release of crash data that might be used in litigation against the government. And so the state DOT said, you can't have it because you might use it for litigation purposes, even though the researchers weren't going to. I think there's a couple of notable things here. One notable thing is that many, if not most states, actually release this data. So Rhode Island is an outlier. In fact, Massachusetts not only releases the data, but has a purpose-built state website that highlights the data. So this is a way that Rhode Island is an exception, but in a bad way. And again, this is something that we are going to try to change, as I'll talk about in a minute. Next is a 2024 decision in a complaint brought by Brian Crandall of our NBC affiliate and Steph Machado of the Boston Globe. This is dealing with the closure of the Washington Bridge in Rhode Island. And once that was closed, a lot of media outlets asked for a lot of records related to the decision to close the bridge. And the governor's office gave sort of wildly competing different cost estimates. to the different media outlets. And at first, the governor's office decided to try to charge these reporters, but very different amounts for these records. Ultimately, the governor's office, under public pressure, decided to release them without charging. But the reporters had appealed this in the meantime before they were released. And one of the things they argued was that the fees were unreasonable. And the Attorney General, much like in that first decision, was basically saying, I have little I can do about the charging of fees here. We have seen fees used as a way consistently by public bodies in the state to sort of discourage broad APRA requests. And I think this is an example of that, but it's also an example of how I think the AG, as well as sort of public pressure, can ultimately lead to the release of records despite these large fee requests. The next one is from earlier this year. It deals with the Brown University Police Department. During campus protests last year, they arrested a number of students and some journalists, in this case from Motif Magazine in Providence, had requested the arrest records of those students who had been arrested by Brown University police officers. And the Attorney General determined that those Brown University arrest records are not public records because Brown University is not a public body. This, in our opinion, is a bad idea because Brown does have those police powers, the ability to arrest and charge people, arrest people, and so their record should be public. Again, we deal with this in a bill in a minute. Another one from this year involves an independent journalist, Steve Alquist. He had requested body-worn camera footage, and that's a theme here in the next couple of slides, from Woonsocket Police. The governor and some other officials had accompanied the Woonsocket Police when they went to a homeless encampment in that city. And when Steve Alquist requested that footage of their visit to the homeless encampment, they actually blurred out or sort of digitally redacted the faces of the public officials and cited privacy. And in this case, the AG came back and said that, you know, a public official does not sort of isn't entitled to that privacy when they're performing a public duty like accompanying the police to this homeless encampment. And so they ordered the release of the unredacted version of the body-worn camera footage. And then the final one is another decision about body-worn cameras where someone had requested body-worn camera footage related to a traffic stop that did not result in the arrest of the individual stopped. And the South Kingstown Police Department was ruled by the Attorney General to have permissibly withheld that body-worn camera footage, in part because there was no arrest made and because of the balancing test and determining that the individual, their right to privacy outweighed the public interest. This goes along with a whole bunch of cases, a bunch of decisions from the Attorney General, not just 2521, but also 2538, 2535, 2531. So like a whole host of cases or decisions this year alone. And this is a reflection of body-worn cameras statewide are fairly new policy in Rhode Island. And so we are starting to see a lot of requests for that footage, and we're seeing a lot of appeals of denials. And we're pretty consistently seeing the Attorney General rule that if it didn't result in arrest, it's not a high-profile incident, they're not going to order the release of the body-worn camera footage. So the final thing I want to talk about before I take your questions are proposed changes to the APRA. So as I mentioned at the top, There have only been a couple of changes to the APRA in the last 4 years, but Common Cause, NEPAC, the Access Rhode Island Coalition has proposed a comprehensive set of reforms to the public records law in Rhode Island. Most recently, that was in a bill S-909 by Senator DePalma and H-6273 by Representative Serpa. And it makes more than 40 changes, proposed changes to the law, but at least four of which are the result of decisions that I just highlighted by the Attorney General. So for instance, it would explicitly make Brown University police records, arrest records, public records. It would allow, much like exists in the federal FOIA, it would allow you, a records requester, to ask the custodian of records to waive the fee for the records based on the public interest in those records being made public. So going back to that first decision involving Tim White and the Providence Police Department, where the Attorney General said, I don't have the power to do this, it would give the Attorney General the power to order the waiver of the fees. It would explicitly require the release of the crash data that the Rhode Island Department of Transportation is not releasing. And although not exactly what we were talking about with body-worn camera decisions, it would require, in the case of a use of force incident, that the body-worn camera footage be released after 30 days in most instances. So as the body-worn camera use sort of settles in, it would make one change to that part of the statute. It makes a whole host of other changes that aren't reflective of decisions that I've highlighted earlier. And those are roughly around a handful of topics. There are a lot of proposed changes involving police records. There's an attempt to narrow the exception for records related to an attorney-client relationship. It would attempt to narrow the exception that exists for the correspondence of elected officials. It would lower the costs that could be charged for obtaining public records, which is something we saw earlier has been a barrier to the press, in particular, obtaining records. And it would increase the penalties for knowing and willful violations by public bodies. It would also require the release, in some instances, of subpoenas, which aren't currently covered by the public records law, and as well as 911 tapes. For the first time, it would create a way that 911 tapes, which currently aren't subject to the public records law, it would create a path for them possibly to be released in certain circumstances. So that's where we are in terms of APRA in the last 4 years, in terms of changes to the law, interpretations of the law that are of note, as well as the open government community's advocacy to improve the law. I'm happy to take your questions.
Just one thing before we wrap up here. Could you give us a little history about that APRA legislation? It's been introduced a number of times. If you could just give us a bit of context outside of the 25 bill.
Yeah. So it's been introduced, I believe, in different forms for about 4 years. It was drafted by the Rhode Island affiliate of the ACLU, but supported by the coalition. And it hasn't moved anywhere. So in Rhode Island, in our legislature, bills that are introduced are not guaranteed. They are guaranteed a hearing, but they're not guaranteed a vote on the substance of the bill. So it's been introduced, as I said, for a number of years, has had a number of hearings, but no substantive votes. It has drawn a lot of opposition from the McKee administration over the years, many departments of state government have opposed various provisions of it. As I said, it's more than 40 proposed changes, so not everybody opposes everything, but most things have at least somebody opposing them. In its most recent iteration, in 2025, we did, for the first time, try to meet some of our critics partway, and we introduced something I didn't highlight in one of the slides, which is language that would allow a public body, in the case of what's referred to as a vexatious requester, to go and seek a remedy from a court if somebody is sort of weaponizing APRA against the public body. But even with that concession, it didn't go anywhere in 2025.
Thank you. Well, hopefully when we have you back in a few more years to give an update, you can talk about all of the changes that did pass, and we can have some better news on that front. John, thanks so much for this update, and many thanks to everyone who joined us today. We provide these lessons as a public service to all of you, so please return the favor and consider supporting our work by visiting nfac.org and clicking Donate. Your contributions are critical to our mission and protecting the public's right to know in all 6 New England states. Thank you again for your interest in keeping government open and accountable, and thanks as always for being a part of our growing NEFAC community. We'll see you all next time. Thanks again.